So, once again, people, this is my Telegram channel. Any doubts or queries that you have, you may post it over here. In the last class, we had just wound up with district collector, the roles and responsibilities. And there I had mentioned that we had just started talking about CAT there. Central Administrative Tribunal. Good afternoon, Satish. Central Administrative Tribunal, what is the purpose of it? Simple it is. In the case, let us say tomorrow you become an officer and you're not happy with the transfer or with a suspension order, you can go to the tribunal directly and get justice. Why you need a tribunal? Why can't you go to the court? Because going to the court means it will take time again. You will have to stand there in the corridor waiting with other murderers, rapists, robbers, etc. Good afternoon, Ayushi. But when you talk about a tribunal, administrative tribunal, this is a court exclusively set up to look into administrative matters alone. They don't look into criminal cases, they don't look into civil cases. And more than IPC section or CPC, that is Civil Procedure Code or Indian Procedure Code or Indian Penal Code or Criminal Procedure Code. These tribunals are mostly guided by the principles of natural justice. Principles of natural justice, when we say, what is the easiest way to understand? They look into the whole case and then they try to see whether the transfer is just or not. That is, under the given conditions, what action was taken on you by the government, is it right or wrong? They look into the whole thing. Law-wise, if I am going to see government transfers Ayushi now, can the government do it? Yes. So, okay, it is legal. End of the story. That's all. But when a tribunal, Ayushi takes the transfer to the tribunal and challenges it, what the tribunal will do, tribunal will start saying that Ayushi has been a no-nonsensical officer. She has been very tough on the land mafia in that region. And that is the reason why this transfer order has come now. She will get a stay for the transfer. Getting the point here. They look into the whole aspect of the case, not just the law. So now, today we will see the structure of tribunal. Once again, like I told you, this is part of your paper 1 actually. So we will look into that, as well as we will look into certain examples to understand the working of it better. Clear? So rural governments also will be starting today. Mohsin, a 1996 batch IAS officer from Karnataka, was suspended by the ECI on April 16th for allegedly searching PM Modi's helicopter in Sambalpur, Odisha against SPG norms. SPG means Special Protection Group. They have only one mandate, that is exclusively take care of the security of Prime Minister as well as the ex-Prime Minister and the immediate family members for a period of 5 years from the date of demitting office. That is, from 2014 to 2019, Prime Minister Manmohan Singh, his wife, his daughter had SPG security protection. After 2019, the SPG cover was removed, but they continue to enjoy what? They continue to enjoy CRPF or CISF protection. Clear? He denied being present at the helipad. CAD stayed the suspension on April 25, reinstating him as secretary in Karnataka's backward classes welfare department, stating SPG protectees are entitled to unrestricted privileges during election. So, helicopter is coming down. Prime Minister Modi's IAS officer at that point, who was on election duty, Mohsin. Okay, he said he needs to check the chopper. SPG said no, because he went ahead and checked the chopper, he was given suspension. Okay. But what he is telling is he was not even present there. Then how can you give me suspension? That is what he is telling. I was not present there. What did CAT say finally? CAT looked into the whole totality of the case. CAT said, listen, you have suspended him on what ground? That he breached SPG security protocol and went and checked the chopper of the Prime Minister. Okay. First of all, SPG protectees do not have some blanket right, are entitled to unrestricted privileges during election. During election time, Election Commission of India and officers under election duty are supreme. They can stop any vehicle, search any vehicle, seize the vehicle if required. But for 9 days, Mohsin, an IAS officer, would have suffered what? Mental torture. For 48 hours, he did not even bother to inform his family. It was only after that he told them that I have been suspended. And thankfully, April 16th, he received it. At least by April 25, the suspension was revoked. Getting the point here. Let's see. The proliferation of administrative tribunals globally in the 20th century included India, where numerous tribunals were established at central and state levels, covering sectors like trade, industry, banking, and taxation. These tribunals aim to provide quick and cost-effective resolutions for government employee grievances related to recruitment and service conditions, addressing issues caused by judicial backlogs and delay. The first Administrative Reforms Commission recommended civil service tribunals as final appellate authorities for major penalties. That means, good afternoon, Suganya. As 20th century became more and more complex, the work started increasing, trade started improving. It was natural that you have to have more bodies, specialized bodies to look into specific matters. आम तौर पर normal courts cannot actually deal with problems like trade, industry, banking, and taxation. So you need specialized courts. Quick and cost-effective resolutions. You want it to be fast. Again, with regard to recruitment and service conditions, addressing issues caused by judicial backlog and delays. Just a minute, people. The first Administrative Reforms Commission recommended civil service tribunals as final appellate authorities for major penalties. The suggestion that we should have a civil service tribunal and it should be the final authority. That means no appeal beyond that. As early as 1969, a committee under the chairmanship of J.C. Shah had recommended that, having regard to the very large number of pending writ petitions of the employees in regard to the service matters, an independent tribunal should be set up to exclusively deal with the service matters. Like I told you, because earlier and all what used to happen was that if let us say Suganya gets a transfer order, the only legal remedy was what? File a writ petition, quo warranto, by what authority has I been transferred now. Getting the point here. So only these writ petitions, and writ petitions, you must understand, it will take its own sweet time. The Supreme Court in 1980 endorsed the establishment of these tribunals to relieve public servants from lengthy courtroom battles. Because like I told you, it is a headache. Imagine, for every transfer you are going to the court and you have to wait there from morning till evening. You don't know when your case is going to be called. The Constitution was amended through 42nd Amendment, Article 323A, to allow for civil service tribunals, leading to the enactment of the Administrative Tribunals Act which empowered the parliament to establish tribunals for disputes involving government entities. So this is the history. Supreme Court also said, let us have these tribunals. Clear? These tribunals provide a platform for agreed parties to seek justice swiftly and affordably, excluding certain categories like armed forces and parliamentary staff from their jurisdiction. That means other than armed forces, because armed forces have their own military courts to deal with things. Then parliamentary staff, that is selected by each of the, that is decided by the government. So leave that also out. Apart from that, every other central government servant, any grievances they have, service related, they will come under what? CAT, Central Administrative Tribunal. As per the Supreme Court judgment dated 18th March 1997, appeals against the orders of an administrative tribunal shall lie before the division bench of the concerned High Court. So you can appeal. You cannot actually have a situation where in a tribunal a verdict is given and that is final verdict. No. The Supreme Court basically gave the ruling that if you're not satisfied with the tribunal verdict, you can challenge it in the concerned High Court. And as if I'm working in the state of Karnataka, I got a tribunal verdict. I can challenge it where? In Karnataka High Court. Then I can take it up after that to the Supreme Court also. The provisions of the Administrative Tribunals Act 1985 do not, however, apply to members of paramilitary forces, armed forces of the Union, officers or employees of the Supreme Court, or to persons appointed to the Secretariat staff of either House of Parliament or the Secretariat staff of state or Union territory legislatures. Again, these are the exceptions, because the staff of the other areas, whatever I have mentioned here, these are all directly recruited by the concerned departments, not through a central level exam or an all India level exam. Clear? Moving on. Structure. CAT, with its principal bench at Delhi and other benches at Allahabad, Mumbai, Kolkata and Chennai, was established on 1st November 1985. The Act vested the Central Administrative Tribunal with jurisdiction, powers and authority of the adjudication of disputes and complaints with respect to recruitment and service matters pertaining to the members of All India services and also of any other civil service of the Union or those holding a civil post under the Union or a post connected with defense. That means defense, when we say which defense? Non-uniformed service. Defense staff is there. People who will work in the canteen or as clerk, peon, all those posts. Or in the defense services being a post filled by a civilian. Getting the point? That means CAT, when we say, it's only what? Central government and All India service. Keep it in mind. That is the easiest way to remember it. Are they under central government? Or are they under AIS, All India Service? CAT will cover it. Any dispute with regard to recruitment, service conditions, you can approach CAT. The Act provides for establishment of state administrative tribunals to decide the service cases of state government employees. Here also, from my personal experience, let me tell you a story. So I have cleared Kerala Administrative Service. Okay. I have cleared it. But due to some reason, government had underreported the vacancies. So we fought a case in the State Administrative Tribunal. We won that case. Government did not take any action. Then we have moved to where? The Kerala High Court. Getting the point here. So, idea is very clear. Once a tribunal gives a verdict, you can approach the High Court. If the government doesn't take an action or inaction, whatever it is. Same thing. If government is not happy with the tribunal verdict, government can approach the High Court also. That is also possible. So in our case, what has happened is Kerala Administrative Service, we have cleared almost around 150 people are there who are awaiting their, postings till date. We are awaiting. This has happened now, let me tell you, 1920 this was. So 2020 to 2025. 5 years we have been fighting the case now in the High Court. Now, High Court is about to give a favorable verdict to us. If it doesn't come, obviously we'll have to go to the Supreme Court. So can you see the path here from straight administrative tribunal to the High Court to the Supreme Court? This will be the same thing if what? If it is CAT. Go to High Court and then to Supreme Court. Clear, people? There is a provision for setting up of a joint administrative tribunal for 2 or more states. Just like a joint public service commission for 2 or more states you can have. Same thing. Composition. Each tribunal shall consist of a chairman and such number of vice chairmen and judicial and administrative members as the appropriate government, either the central government or any particular state government singly or jointly may deem fit. Matlab, there is no such condition as to who should be appointed here. Means there is a very good chance that risk of political appointments are very, very high. People who have worked favorably for the government, people who are or administrative officers who are very favorable to the current government, etc., they can get a nice plump posting. A bench shall consist of 1 judicial member and 1 administrative member. The bench at New Delhi was designated the principal bench of the CAT and for the state administrative tribunals. The places where their principal and other benches would sit are specified by the state governments by notification. So same thing. CAT, principal benches where? Principal bench, don't think that it is the head bench or something. Where, okay, there is a bench in Chennai. CAT bench is there in Chennai. So Chennai gave me a verdict. I am not happy with it. So can I approach the Delhi bench for a appeal? No. Chennai bench gives me a verdict which I am not satisfied with. What will I do? I should approach the Chennai High Court. Tamil Nadu High Court is where I will go. Principal bench means just we are calling it the main bench. That's all. There is nothing like they are doing something different from the other benches. No. Getting the point here. For CAT, it is Delhi. For each state administrative tribunal, they'll have a main bench and what is it? Other benches also. Other branches will be there. Qualifications for appointment. In order to be appointed as chairman, a person can be a High Court judge or a retired person, but a person to be selected as the vice chairman prior to the initiation of the act shall be chosen to the post of chairman if he or she has worked as vice chairman for a term of at least 2 years. Means there is no specific qualification for vice chairman. And if anybody has worked as a vice chairman for 2 years, automatically they become eligible to become what? Chairman. If they were a vice chairman before the act came into picture. That is, I am a vice chairman. Okay. Act has already come. This is 2025. Act has already come. Correct? 1985 itself this act was there. Now, I am a vice chairman, but am I a High Court retired judge? No. Can I become a chairman? No. Because what does the act say? A High Court judge or a retired person. So I cannot be appointed. So the last non-legal chairman's appointment would have got over when? In 1985 itself, when the act came into power. That was the last time. After that, no. To be an administrative member, a person should have experience as the secretary in the central government or belonging to other services under the government of India or under the state government and has received salary equivalent to that of the government secretary or has worked as additional secretary for the term prescribed under the Act. So if you look at the chairman, it is somebody from a legal background. If you look at the administrative member who should be present in the bench, they are all of the post of what? Secretary, additional secretary, etc. Therefore, there is a very good chance that it will be an IAS officer. So IAS domination it is. Then, and goes without saying, both of this are at a risk of what? Nepotism and favoritism. Because these are all very general statements. These are additional secretary. So I will definitely appoint somebody who is going to give me favorable verdicts. Easy it is, because ultimately the government of the day decides. If it is central administrative tribunal, union government can choose a judge who is favorable for them and administrative member who is favorable for them. Same thing applies for the state too. The persons under the All India services shall also be eligible to be appointed as administrative members according to the terms specified in the Amendment Act 2006. A person shall be appointed as a judicial member if he or she is working in the legal affairs department, as secretary of the central government, or has held such other post in the legislative department. A member secretary under the Central Law Commission can also be appointed as judicial member. All of these are for your information only, people. Just in case you get a direct question, briefly define the structure of a tribunal. 10 marks in case you get, just to fill it up. Basic level jankari. Clear? Appointments. The chairman, vice chairman and every other member of the CAT shall be appointed by the president. And in the case of state or joint administrative tribunals, by the president after consultation with the governors of the concerned states. So, CAT and SAT both are president. Just that with SAT, president will have to consult the governors of the respective states. But no appointment can be made of a chairman, vice chairman or a judicial member except after consultation with Chief Justice of India. The judicial members, before appointing them, consultation has to be made with whom? Chief Justice of India. Moving on. Term of office. The Constitutional Amendment Bill 2012 approved by the central government provides that the chairman, vice chairman or other members shall hold office for a term of 5 years from the date on which he enters upon his office or until he or she attains the age of 68 in the case of chairman or vice chairman, 65 in the case of a member, whichever is earlier. This is the time duration. 65 for a member, 68 for a chairman or a vice chairman, total 5 years. Resignation or removal. The chairman, vice chairman or any other member of the administrative tribunal may by notice in writing under his hand address to the president. Not a surprise, because president is the one who appoints you. Resign from his office but shall continue to hold office until the expiry of 3 months from the date of receipt of notice or expiry of his term of office or the date of joining by his successor, whichever is earlier. Why? At least for 3 months. That is, if I give my resignation letter today, at least for 3 months I will have to continue, minimum. During that 3 months, if somebody joins, if my replacement is found within that 3 months, then I can live. But before that, I'm not supposed to live. That is the idea, because you shouldn't have a gap there. There should not be any interregnum. They cannot be removed from office except by an order made by the president on the grounds of proven misbehavior or incapacity after an inquiry has been made by a judge of the Supreme Court and after giving them a reasonable opportunity of being heard in respect of those charges. Same thing, almost we have read the statement in multiple places, especially with regard to Supreme Court judges removal or High Court judges removal, etc. Not telling Parliament is removing, but almost same I'm telling, because an inquiry is there and you are given an opportunity to present your side of the case. Only then the removal can be made, and that too by the President. As per the Constitutional Amendment Bill 2006, central government, if it is of the opinion that the continued existence of CAT or any of its branches is not necessary, it may by notification abolish any of them. That is basically central government can remove a bench or branch of a CAT, telling that it is no more needed there. Is it so? What does the statistics tell us? Is CAT no more necessary? CAT is having very few cases or more number of cases? Well, we will wait for an example. Eligibility for further employment. The chairman of the CAT shall be ineligible for further employment under either central or state government. But vice chairman of the central tribunal shall be eligible to be chairman of that or any other state tribunal or vice chairman of any other state or joint tribunal. The chairman cannot be appointed anywhere. Vice chairman can be appointed as either the vice chairman or as the chairman of a state or a joint tribunal or the central tribunal also. The chairman of a state or joint tribunal shall, however, be eligible for appointment as chairman or vice chairman of any other member of the central administrative central tribunal or chairman or any other state or joint tribunal. That is, if you are chairman of central administrative tribunal, no more appointment either under the center or under the state. But if you are the chairman of a state administrative tribunal, you can be made the chairman or vice chairman of another state. You can be made the chairman or vice chairman of center also. Both are possible. The vice chairman of the state or joint tribunal can be the chairman of the state tribunal or chairman, vice chairman of the central tribunal or any other state or joint tribunal. A member of any tribunal shall be eligible for appointment as chairman or vice chairman of such tribunal or chairman, vice chairman or other member of any other tribunal. Other than the appointments mentioned above, vice chairman or member of a central or state tribunal cannot be made eligible for any other employment under the government of India or under the government of a state. Same thing. With regard to vice chairman also, can only be appointed in the tribunals of the center or of another state only, not any other appointment. Alright, all these are just for your information only, people. The chairman, vice chairman or other member shall not appear, act or plead before any tribunal of which he or she was the chairman, vice chairman or member. The chairman shall exercise such financial and administrative powers over the benches as are vested in him. The salaries and allowances and other terms and conditions of service, including all retirement benefits in respect of chairman, vice chairman and members of the tribunal, shall be such as prescribed by the central government and cannot be varied to their disadvantages after appointment. This point here, that is, the chairman, vice chairman or any member cannot appear or plead before a tribunal where they had been a member or a vice chairman or a chairman. Why? To prevent favoritism / bias. The Administrative Tribunals Act 2006 was enacted on 29 December 2006 to make alterations to the Administrative Tribunals Act 85 and certain changes were brought about in the Act. The new provision was included according to which a person can be chosen to the post of chairman only if he or she is a High Court judge or retired person. But a person to be selected as the vice chairman prior to the initiation of the Act shall be chosen to the post of chairman if he or she has worked as vice chairman for a term of 2 years. Again, the same thing only, what we already saw. Jurisdiction, power and authority. Chapter 3 of the Administrative Tribunals Act deals with the jurisdiction, powers and authority of the tribunals. Section 14, Clause 1 of the Act vests the CAT to exercise all the jurisdiction, powers and authority exercisable by all the courts except the Supreme Court of India under Article 136 of the Constitution. This relates to matters of recruitment and other service matters in respect of officers belonging to All India Services or of members of civil services of the Union or those holding civil posts under the Union or defense services. No court in the country except the Supreme Court is entitled to exercise any jurisdiction authority in matters of service disputes. Clear, people? That is, when it comes to matters of jurisdiction, powers and authority with regard to service matters, CAT will have power. Complete power like a court. The same authority has been vested in the state and joint administrative tribunals. One of the main features of the Indian Constitution is judicial review. There is a hierarchy of courts for the enforcement of legal and constitutional rights. There is no such hierarchy of administrative tribunals, and regarding adjudication of service matters, one would have a remedy only before one of the tribunals. This is in contrast to the French system of administrative courts, where there is a hierarchy of administrative courts and one can appeal from one administrative court to another. Bottom line is this much. Like I told you earlier, from CAT, you don't have another court of appeal here. Another administrative tribunal you don't have. From CAT, you go to High Court. From High Court, you go to Supreme Court. For SAT also, it is the same thing. You go to the High Court and from there, you go to the Supreme Court. French system is, they have a separate set of integrated judiciary. That is, lower tribunal, middle tribunal, upper tribunal they have. But in India, with regard to decisions of the tribunals, one cannot appeal to an appellate tribunal. Though Supreme Court under Article 136 has jurisdiction over the decisions of the tribunal, as a matter of right, no person can appeal to the Supreme Court. It is discretionary with the Supreme Court to grant or not to grant special leave to appeal. The administrative tribunals have the authority to issue writs. In disposing of the cases, the tribunal observes the canons and principles and norms of natural justice. The Act provides that a tribunal shall not be bound by the procedure laid down in the Code of Civil Procedure 1908, but shall be guided by the principles of natural justice. Too much of content, right? What is this? What does it mean totally? Let's take one by one. You don't have an appellate tribunal in India. That much you would have understood, right? From CAT we go to High Court. From High Court we go to Supreme Court. Now there is Article 136. When we mentioned it initially also, you would have wondered what is Article 136. Article 136 simply means a special leave petition. Special leave petition simply means, if I am Supreme Court, you basically want me to halt all the proceedings and take up your case. That is what special leave petition means. Halt everything, please look into my case. It is left entirely to me whether I want to take up your case or not. Number one. Number two, it is not that when I take up your case, I'll call for a hearing. I'll just look into the main content of it and I will see that, okay, there is some merit in this and I can, and you're demanding a stay or you're demanding something else or you're demanding immediately to look into it, whatever be it, I will grant you that temporary stay till I take it up for hearing again, which can be after 2 weeks, 3 years, whatever. That is the purpose of it. So the special leave petition power tribunals don't have. It is entirely discretionary for the Supreme Court to actually entertain a special leave petition. Means if Suganya is not satisfied with the transfer what she got, can she appeal directly to the Supreme Court as a matter of right under Article 136? Please stop all the proceedings and look into this matter of mine. No. She will have to go there where first the tribunal, then the High Court, then the Supreme Court. Why? Because again, if you would have read it in your polity, you will remember where relief is available through the lower courts, one must first approach them before going to Supreme Court. There are lower courts, tribunal is there, go there first, then go to the High Court, then let it come to the Supreme Court. Getting the point here? That is what it means still here. Administrative tribunals can issue writs. Then, tribunal observes canons and principles of natural justice. They are not bound by what? Like I told you, civil procedure, but shall be guided by principles of natural justice. Tribunal shall have power to regulate its own procedure, including the fixing of the place and time of its inquiry and deciding whether to sit in public or private. A tribunal has the same jurisdiction, power and authority as those exercised by the High Court in respect of contempt of itself. That is, punish for contempt, and for the purpose, the provision of the Contempt of Courts Act 1971 have been made applicable. This helps the tribunals in ensuring that they are taken seriously and their orders are not ignored. And means tribunal orders are very, very, very strict. These are. Getting the point here. These are very, very strict. So in my case also, that is the same thing that has happened. Even after the state administrative tribunal ruled in our favor, still the government did not take any action. So we could have proceeded with contempt proceedings, but contempt is not enough here, right? We need to take it up further than that. We need that a proper order telling that, okay, these many ranks, what is it? As per government order, these are the posts assigned to them with immediate effect. That is what we need. So we didn't go for contempt proceeding. We straight away approached High Court telling that we have a positive order from the administrative tribunal, but the government is yet to take any action on it. Clear? Advantages and limitations. The rendering of administrative justice through administrative tribunals serves the varied. Okay, 1 minute. Any doubts so far, people? Anybody with the tribunal working? Any questions? Okay. The rendering of administrative justice through administrative tribunals serves the varied and complex needs of modern society more adequately than any other method. It has also proved useful and effective. There are certain advantages of the tribunals, which are: number one, they are appropriate and effective. The administrative tribunals are not only the most appropriate means of administrative justice, but also the effective means of providing fair justice to individuals. Now, the public service employees feel assured that in case of denial of justice and fair play to them, tribunals restore to them the benefits that rightfully belong to them. The main idea is that they can go directly there. Best thing to do. All right, that is the easiest way to ensure that, okay, speedy justice is there. Because exclusively to look into your service matters, you have a special court. Fine. Flexibility. There is a considerable amount of flexibility and adaptability in the functioning of tribunals. Principles of natural justice play an important role in the operation of tribunals. They are not bound by rigid rules of procedure or previous decisions of rule of law. If the court is giving favorable judgment, then when the government is not accepting, that is the drawback of tribunal. If court gives an order and it is not followed up by the government, there is nothing much the court can do there. That's it. What can they do? Ask the chief secretary to come, because it's only a tribunal. Understand that. The only other option is what? Go for the next court. The government is not doing their job. The only other option is what? Go to the next court now. That's it. Getting the picture here. That is the drawback also. It's not that everything will happen so fast, so quickly. Okay, you went to the tribunal, immediately everything will go smoothly. No. That is the drawback. Government, what is it? Gives you a transfer. You challenged it. Tribunal gave a positive verdict. Government takes it to the High Court then. Getting the point here. So there is no compulsion as such to follow it, get it done. And again, it depends on what? The nature of chairman who is sitting there, nature of vice chairman, etc., who are sitting there. They have to feel, why is it that we gave an order and why didn't you people follow up on that? I am issuing contempt proceedings against the chief secretary of the state. That is the next follow-up. But generally, they won't do it. Why? Who is the administrative member in a tribunal? IAS officer. Who was a secretary at one point of time? Who is the current chief secretary? That is also an IAS officer. By no stretch of imagination, one IAS officer will go and complain or put another IAS officer in trouble. That is a rarity in our country. When trouble comes, everybody will become one. Getting the point here? Not bound by rigid rules of procedure and not bound by previous decisions or laws. Now, I have been telling you from day one of the classic feature of bureaucracy is, let us say, I am Satish's senior officer. I have signed many documents and many copies, issued many orders. Satish became an IAS officer and Satish came to my post. Okay, I got transferred, whatever. Now, what will Satish do? He is new. Satish will refer to whatever orders I made, whatever documents I signed. He will use that as a reference to take his decision. Correct? Not a tribunal. It means Suganya could have got a stay order against her transfer. Looking that, so Suganya got a transfer, then I will stay order against a transfer. Then Satish also thinks, oh, okay, then I will also go and put. Maybe I will also get it. No. Both the cases could be absolutely similar. That is, Suganya's case is also similar to Satish's transfer case. But Suganya got stay, Satish didn't get stay. That means each case is looked at its own merit. Just because Suganya got a stay order doesn't mean that Satish will get it. That means no guarantee. Then, while justice by the courts tends to be highly technical, tribunals are free from technicalities of law. The rules of natural justice are adaptable to the situation. That is what I told you in the beginning. Principle of natural justice means you look at the whole case. So when you look at the whole, what will happen? It will start varying from individual to individual. Satish's case will be slightly different from Suganya's case. So, Suganya got a stay, but Satish will get something. I mean, Satish is not going to get it. So, this way it will vary. Less expensive. Justice provided by administrative tribunals is inexpensive in terms of costs involved. That is true. Because you don't have to hire a very expensive lawyer and all. You can easily present the case by yourself. This is in contrast to the long and cumbersome procedures involved in judicial courts and huge costs incurred in engaging lawyers, court fees, and other incidental expenses. Hence, the tribunals have now become popular judicial forums which provide easy accessibility to the government employees who are encouraged to move the tribunal even in minor service matters. Everybody loves this because you don't have to hire anybody special. You yourself can go present your case because you can easily present the documents. These are the reasons why I'm getting transferred. This is the action that I had taken. This is the whole totality of the case. They will hear it. They will immediately dispose it off also. Relief to courts. Administrative tribunals have provided great relief to the judicial courts which are preoccupied with so many petitions relating to civil, criminal and constitutional matters. Despite these advantages, there are certain limitations in the functioning of tribunals. That means, to a certain extent, it has helped in reducing judiciary's burden. Separately, if tribunal is there, from tribunal verdict is coming out, judiciary can focus on what? The civil cases, the criminal cases and the constitutional cases. So when you look at it, you feel, wow, tribunals, so nice. Is it so? Let us look at its disadvantages. Administrative tribunals do not rely on uniform precedent and hence this might lead to arbitrary and inconsistent decisions. That means you cannot predict anything here. Almost every decision here will be what? Unprogrammed. Because each case on its own merit means each decision will be on its own merit. There is no hierarchy of administrative tribunals, and this has completely excluded the scope of judicial review on service matters. True, right? Based on principle of natural justice, CAT gave an order. Now the order goes to the High Court. High Court will look at what? Law, not principle of natural justice. So there itself it is gone. The purpose is lost. Getting the picture here? CAT will look into what? Totality of the case. Agreed. From there, I did not like the verdict. I took it to the High Court. High Court I go into. High Court will look into what? The law. So DGP Sen Kumar. This was an old case, okay? He was removed from the post of DGP owing to a sensational murder and rape and murder of a woman from a lower caste in the state of Kerala. He was removed. He challenged it in the tribunal. He lost it. He took it up to High Court. There also he lost it. Finally, it went up to Supreme Court. What Supreme Court said was that DGP can be held responsible. But how will DGP alone be getting the punishment? You are holding the DGP responsible for a murder and for the rape and murder. We understand that. We have no issues with it. But if you are transferring everybody, if you have removed this particular individual from the post of DGP, what about the investigating officer? What about the SP of the district? What about the police constables? What about the inspectors? What about the Home Minister? When all these people are continuing in their job there, why is it that only the DGP is being held responsible? Very valid question. Supreme Court asked. Supreme Court did not say that removing him was a bad thing. Supreme Court said, okay, you're punishing somebody for not doing their job. Agreed. But why are you punishing only one individual? Punish everybody. Getting the point here. And by that Supreme Court order, they had to reinstate him back. The state government had to bring him back. The comedy here was, or the irony here was that he was removed. Another DGP was appointed. Then again the DGP is changed. Because this fellow got his post back. By then, hardly 2 months was left. For what? For his retirement. After all the court, kacheri, this, that, etc., hardly 2 months he had. Clear? The tribunal consists of administrative members and technical heads who may not possess any background of law or judicial work. Because law also you should know, right? Simply you cannot go everything by principle of natural justice. The administrative tribunals, as discussed earlier, have the power to issue writs, which till now was exercised only by Supreme Court and High Court under the Constitution. They are also issuing writs means it's like not that it is a bad thing, but this is not something that was envisaged under the Constitution. Getting the point here? That is like giving them more powers. One more inadequacy noticeable in the present administrative tribunals is from the structural functional angle. This is the absence of an appellate forum within the tribunal, which causes considerable inconvenience. For example, if a bench of tribunal gives a judgment, it has got applicability all over the country, as there is only one CAT for all of India, and the various benches located in different parts of the country are parts of the same tribunal. The same point what we have been telling from day one, from the beginning of our lecture, that is, anywhere you got a verdict from Lucknow, you got a verdict from Chennai, you got one from Bangalore, you got one from Allahabad, wherever it is. After that, what is the only option available? High Court. Not that you can take it to a higher tribunal. Current situation, the data, citing 1,350 cases pending disposal for more than 10 years, a parliamentary committee has asked the CAT to decide them on a priority basis, specifically the ones related to pensions and senior citizens. 1,350 cases that are pending for more than 10 years. Why was CAT formed? To ensure speedy justice. And this is the speed. The tribunal adjudicates service matters of central government employees. As many as 80,545 cases are pending in different benches of the tribunal as on December 31st, 2022. Of these, 16,661 cases are pending for 0 to 1 year, 46,534 for 1 to 5 years, 16,000 for 5 to 10 years, and 1,350 for more than 10 years. The department-related Parliamentary Standing Committee on Personal, Public Grievances, Law and Justice said in its report. This level of data you need not remember, but at least you can remember this much. More than 80,000 are pending, which is almost the same number of cases that are pending even in Supreme Court. Then, in that 1,350 cases are pending for what? More than 10 years. That means we can easily say some of them would have filed this case, they would have already died without even getting to know what is the verdict, what has happened to their pension, what has happened to their transfer, what has happened to their promotion, what has happened to their suspension. They would have passed away also. That is the reason why they told one related to pension and senior citizens, solve those first. That is, let us try to give them justice before they die. The panel said according to CAT rules 1987, every application should be heard and decided as far as possible within 6 months from the date of its registration. The committee noted that mounting pendency of cases in CAT, and it felt that one of the major reasons for the delay is the non-availability of sufficient number of members. That is the main reason. The judicial member or administrative member you talk about, they are not there. The sanction strength of members in CAT is 70, 35 judicial members and 35 administrative members. As on 2022, 53. 28 judicial members and 25 administrative members, including the chairman, are in position and 17 posts are vacant. The committee said it was informed that in some benches of the tribunal, cases are pending for want of division bench as sufficient number of division benches are not available due to vacancy of members according to the report. That means more division benches. You need more and more, not lesser. So, there is a rule telling that central government can abolish a division bench if workload becomes less. It is increasing actually. That means what? You need more division benches. Panel inferred from the data provided by the tribunal that Allahabad, Bangalore, Hyderabad, Jammu and Patna benches are operating with 50% of the sanction strength, it said. 50% only is there. So how are they even dealing with it? Now that is the next interesting part. So let us say I am the Chennai bench. Bangalore is only having 50%. I am listening to even Bangalore cases. So my workload will again increase. The committee recommends that steps should be taken to ensure that these vacancies are filled up in the earliest. The committee is happy to note that CAT is contemplating to implement an advanced case information system which facilitates hearing of cases through video conferencing and complete digitization of the functioning of the tribunal, and hopes that it is operationalized soon. That is some of the ways. Go for video conferencing. Stop asking people to come to the tribunal directly. All right. The CAT today issued notice to UPSC on a plea seeking reduction in the cutoff for qualifying Part 2 exam conducted by UPSC last month from 33% to 23%. CAT is for what purpose? Service related matters, issues regarding it. And some idiot has gone to CAT telling that ask UPSC to reduce CSAT's cut off from 33% to 23%. UPSC is a constitutional body. They don't even have to listen to the government. They don't even have to listen to the government. Why will they listen to CAT? Getting the point here. But again, first of all, what is CAT's job? Why it is not even CAT's job to decide such things. To tell UPSC, why don't you reduce the cutoff? Any further reduction in that cutoff, what will happen? CSAT will become even more tough. I remember when CSAT was not having, when CSAT was counted, marks were counted, there was this last section. Always towards the end, you will have these small 4 passages. Anybody with an average knowledge of English also will be able to solve them. And the year from where CSAT was made qualifying, from that year onwards only, which of the most which among these is the most logical conclusion that cannot be inferred from the above passage? These type of questions started coming in. Clear? Just showed it because these days there are different types of idiots out there who are sitting jobless. Sit and study and find out how to crack the exam. And rather than that, they are planning all the ways to irritate UPSC. The Supreme Court in May 2022 took serious note of huge vacancies in the CAT and said that the entire tribunal has collapsed. The top court noted that the center in its affidavit has said that the benches that have vacancies are functioning through physical or hybrid mode and virtual modes by joining members from other benches. It directed, in view of the matter, since the vacancies in the CAT would impinge upon the citizens' right of access to justice, this court is of the considered view that the exercise of jurisdiction of Article 142 is mandated. And the center is not clearing the vacancies. Vacancies are remaining as it is. I am sitting in the Chennai bench and I am listening to cases and I am joining online to listen to the cases in Bangalore bench. So Supreme Court decided under Article 42 we are going to interfere. The top court directed, pending further orders, the incumbent holding the post of members of CAT, either the judicial member or the administrative member, shall continue to function even after the completion of their tenure, subject to their consent and availability. That means you, center, you cannot make these people retire. So if I am an officer, I am already 60 years old. Okay, I am a judicial member. I am already 60. If I am willing and I am okay with it, even after 60, I should continue in the tribunal. Center cannot retire me off. This is the direction given by the Supreme Court. Why? Huge pendency of cases because of vacancies. Clear? 2023, the Ernakulam bench of the CAT has directed the Kerala state government not to issue orders of appointment, transfers and postings to IAS officers in cadre posts without obtaining recommendations from the Civil Services Board. Saw that? That is called power. Telling the state government, you cannot issue orders of appointment, transfers and any postings of IAS officers without consulting with Civil Services Board in the state. Srinagar 2023, the CAT has held that an employee has no vested right to claim transfer or posting of his choice, and individual convenience of a person in the service is always as per the public and administrative needs. That is, I cannot say, no, I want that posting. I don't want to go there. That transfer I didn't like. There is nothing called as individual choice here. Or when it comes to postings, what is the main thing in consideration? Public and administrative needs. Why CAT came out with such a verdict? Because it has become a frequent affair now. Transfer comes immediately, they'll go and challenge it. No expense, right? No expense, so they will challenge it. So much so that now CAT had to finally come out and say, listen, you cannot cite personal reasons as a reason for not taking up a posting or not taking up a transfer. Because these all are based on what? public and administrative needs. Until and unless you are not able to prove that there is some vengeance here, this is political vendetta, padla from the politicians, until and unless you are not able to prove it, take your transfer, go to your next posting. Clear? 2024, the Supreme Court on Tuesday emphasized the principle that Constitutional Court should exercise restraint while reviewing decisions of specialized tribunals, particularly in matters requiring technical expertise and sectoral knowledge. Means Supreme Court as well as the High Court also. Don't interfere with the decisions of tribunals too much. If they gave a verdict, let it be. Because there is a lot of technical things surrounding it. Don't try to hastily change that decision. Overturn the decision. Tribunals cannot outsource opinions for decisions. Cannot. Supreme Court declaration means, oh, this particular case, let me ask one person who is working in that department. Let me ask them and see what decision I should take. You cannot. Tribunals cannot direct the government to frame policy. True. Tribunals only what you have been created for, only for that purpose alone, you can take a decision. Clear? With that, finally we come to an end of what? District administration, along with that the tribunals. Clear? Next, as I have been telling you from day one, this next two topics, rural governance, urban governance, are like the favorite topics of UPSC. I wouldn't be surprised if you get, at least 2 questions from these topics also. Don't be surprised. Very, very, very important. And once I teach you this, you will really understand what is the problem with your village, what is the problem with your city. Clear? So let's do one thing. Let's take a break. We will join back at 2:45. Okay. All right, people, welcome back. So, rural development, when we talk about, like most of you will be already knowing it, we are talking about what the Panchayati Raj Act. So, the structural part of it, that is the amendment. What is the structure? The Panchayat president, elections being held, all that. It's what the static portion. Where question from a static portion from this section, very, very rare it is. Generally, they will ask the current related stuff over there. So, always in the newspaper, whenever you find any data or any news with regard to rural governance, please make a note of it. Without further delay, let us get right into it. The introduction. The Rig Veda, one of India's oldest sacred books and historical sources, mentions village communities across the subcontinent that were self-governing over millennia, serving as the main interface between the predominantly agrarian village economies and the higher authorities. Custom and tradition elevated these earlier councils or assemblies called Sabha to a position of considerable authority. Slowly, they assumed the form of the Panchayat, an assembly of 5 respected elders. These panchayats in North and South India became the pivot of administration, the focus of social solidarity, and the principal forum for the dispensation of justice and resolution of local disputes. So, from the Vedic time period onwards, we had self-governing village communities, which later evolved to become Sabha, and Sabha became Panchayat. Panchayat. 5 elders. When today in most of the villages in our country still follows this Panchayat. That is the elderly people of a village. But we don't call them Panchayati Raj institution. Why? Because those Panchayats, what I have mentioned right now, these are Ka Panchayats. Yes, it will have elderly people, generally from upper caste, and it's a completely non-elected body. Clear? During the medieval and Mughal periods, these characteristics of the village panchayats remained unchanged. Evolution of PRI. 1870. Lord Mayo, Viceroy of India, initiated decentralization to enhance administrative efficiency and bolster imperial finances. The Bengal Chowkidari Act of 1870 marked a pivotal move, reintroducing village panchayats of nominated members, empowered to levy taxes for local watchmen, overseen by district magistrates. The 1880 Famine Commission identified the lack of local governance as a key barrier to distributing relief during famines, emphasizing the imperative of extending self-government to rural areas. Something which we've already seen under British administration. 1882. The Ripon Resolution of 1882, under Lord Ripon's tenure as Viceroy, established rural local boards with significant elected representation and non-official chairpersons. While initial implementation was gradual, it elevated rural administration and popularized the concept of self-government in British India. 1907 to 1909. In 1907, the government formed a 6-member Royal Commission on Decentralization, whose 1909 report expanded on the Ripon's resolution principles and underscored the significance of panchayats in Indian governance. Let me tell you, this topic as a whole, evolution, it's for your information. Plus, we have covered it already under British administration, our very first chapter. Clear? That is the reason why I'm not bothering to again revisit it again. It's just understandable. I've just clubbed and combined things. That's it. The 1919 Montego-Chelmsford reforms designated local self-government as a transferred subject under diarchy, placing it within the purview of Indian ministers in the provinces. The Montego-Chelmsford reforms proposed maximizing local self-government's representativeness and accountability, advocating for complete popular control and maximal autonomy from external oversight. 1935 to 39, the Government of India Act 1935 and its introduction of provincial autonomy marked a significant milestone in the evolution of panchayats. With elected provincial governments, most provinces passed laws to democratize local self-government institutions including village panchayats. 1948 to 1950. Article 40 of the Constitution mandates organizing village panchayats with powers for self-government, affirming their role, fundamental role. This principle has been enshrined in entry number 5 of the state list since the Constitution's adoption on November 26, 1949. So the historical part we saw right from Rigvedic time period all the way to British administration. British administration, we know how it strengthened or rather kept on telling why you need panchayat to solve the problems of governance at the local level, to give relief very quickly and to pacify the people. Thoda shant rakho in logon ko. If you give them some local government, they will be busy with that. That was the British idea. Post independence, the local government, if you actually see, was brought under the entry number 5 of state list, which means state is single-handedly responsible for what? Ensuring local governance. Make no doubt about it. Taking it further forward, 1952, community development projects were inaugurated in 1952, modeled after the earlier experiments at Shantiniketan, Baroda and Nilokheri. In 1957, the Balwantrai Mehta Committee recommended statutory representative bodies for organizing public participation in community development projects, a pivotal step in establishing Panchayati Raj. Following this, the National Development Council adopted the democratic decentralization principles of Balwantrai Mehta Committee report, assigning states the task of devising suitable structure. So Balwantrai Mehta Committee recommended what? Statutory representative bodies for organizing public participation in community development projects. Local government you need. That is what Balwantrai Mehta Committee suggested. What did the center do? Center basically told the states, you frame policies for forming Panchayati Raj institutions at local level. You frame your own policies. This era saw the term Panchayati Raj emerge, symbolizing governance connecting the Gram Sabha to the Lok Sabha through organic participation. 59. The system of Panchayati Raj was first implemented in Rajasthan on 2nd October 1959 at Nagaur. 1978, the Ashok Mehta Committee report of 1978 recommended that Panchayati Raj be included in the constitution. Inspired by the Ashok Mehta Committee, states like West Bengal, Karnataka and Andhra Pradesh revamped their Panchayati Raj system. Empowering local bodies with enhanced authority. So Balwantrai Mehta Committee only said what? We need something at the local level. Statutory. Statutory means formed by a law. Make a law to form some sort of system at the local level. Alright. Center told the states, Ja beta ja, jeele apni zindagi. Do whatever you people feel apt. For that you do. What did Ashok Mehta Committee suggest? Ashok Mehta Committee told, give it constitutional status. Union government has constitutional status. State government has constitutional status. Same thing you provide here. Based on the Ashok Mehta Committee, what happened? West Bengal, Karnataka and Andhra Pradesh made changes to their Panchayati Raj institutions. Aage. These initiatives, known as second generation panchayats, became influential models for future reforms. 91 to 93. The government introduced the 72nd and 73rd Constitution Amendment Bills, largely based on earlier bills from the 8th Lok Sabha, but updated with modifications. After referral to a joint select committee, these bills were passed by the Lok Sabha on December 22, 92 and by the Rajya Sabha on December 23, 92, largely aligning with 1989 initiative. After passing through Parliament, the bills were renumbered as 73rd and 74th Amendments. This is why there is always a confusion whenever any polity faculty teaches this. That is, when it was tabled, it was 72 and 73. By the time it got passed, the number became 73 and 74. So which one is correct, sir? Which numbering? Any you use, nothing will happen wrong. If you are talking about bills, it is 72 and 73. If you are talking about the act, it is 73 and 74. Getting the point here? Okay. Upon receiving ratification from more than half of the state assemblies, President of India granted assent. Consequently, the Constitution 73rd Amendment Act 1992 came into effect on April 24, 93, followed by the Constitution 74th Amendment Act 1992 on June 1, 93. These amendments introduced Part 9 titled the Panchayats and Part 9A titled the Municipalities to the Constitution. About Part 9 and Ministry of Panchayati Raj. Okay. Just give me a minute here. The 73rd Amendment to the Constitution of India 93 introduced Part 9 mandating local participation in rural development through the Panchayati Raj system. This established Panchayat with constitutional significance. Ministry of Panchayati Raj was established on May 27, 2004 to oversee these institutions. That means whatever institutions have been created under the 73rd Amendment Act, इसका देखभाल कौन करेगा? Ministry of Panchayati Raj. Only what? Panchayati Raj system, not your municipalities. That comes under urban. Only to look into Panchayati Raj system, you have what? Ministry of Panchayati Raj. That's the primary objective of overseeing the implementation of Part 9 of the Constitution, implementation of the provisions of the Panchayats Act 1996 in the 5th scheduled areas. And operationalizing district planning committees in terms of Article 243 ZD of Part 9A of the Constitution. District planning committees. District planning committees means for the whole district, urban and rural plans put together. Okay, what is PESA? That we will, 5th schedule areas, we will see it in a while. The ministry primarily focuses on enhancing panchayats functioning through policy interventions, advocacy, capacity building, persuasion, and financial support, considering that most actions, including lawmaking, are under the purview of state governments. The ministry aims to empower Panchayati Raj institutions as effective, efficient, and transparent agents of local governance, social change, and public service delivery, meeting local aspirations. It focuses on strengthening administrative infrastructure, basic services, and capacity building of rural local body functionaries through technology and training. Ministry's roadmap to realize the above objectives is through 3 pillars. Provision of basic services through finance commission funding. First and the foremost thing. That means from finance commission, Panchayati Raj institutions gets its funding. How? Largely in the form of grants. That is the first thing. Number 2, capacity building of rural local bodies through the revamped means renovated, changed Rashtriya Gram Swaraj Abhiyan. That is again what is it? A scheme exclusively meant for the rural local bodies. Number 3, convergent holistic planning through inclusive and participative process through Gram Panchayat Development Plan. Clear? So whatever above objectives we told about, that is strengthening administrative infrastructure, basic services and capacity building through technology and training, or even when we talk about policy interventions, advocacy, capacity building, persuasion, and financial support, local governance, social change, and public service delivery. All of this is going to be done through what? These three things. Funding from Finance Commission. Scheme is Rashtriya Gram Swaraj Abhiyan. Last one is Gram Panchayat Development Plan. Through these three things, we are planning to achieve all these objectives. Aage. The constitution envisages that panchayats will function as institutions of local government and prepare plans and implement schemes for economic development and social justice, but leaves the precise devolution of powers and authority to panchayats to the states. Means, that is, panchayat will make their plan. Panchayat will have their own fund. Panchayat will decide matters for all the panchayat. This is what our constitution or 73rd Constitutional Amendment Act says. Beautiful. But what is the problem? How much power the panchayat will have? Who will decide that? State. So if state decides, no, I don't want to give much power to the panchayat, they should be dependent on me, means they will be dependent. That means 73rd Constitutional Amendment Act, when you read it in the Constitution or the Act when you read it, it is so great. But the practicality of it, that is, how much freedom should be given to the panchayat to make their own plan, decide their own development agenda? States will decide. Why? Because state has to give that power. Devolution of powers and authority is left to whom? The states. Article 243G of the Constitution stipulates that panchayat should plan for and implement schemes for local economic development and social justice. Article 243ZD mandates the establishment of district planning committees to consolidate rural plans from panchayats and urban plans from the urban local bodies into district plans. That is, articles and all are looking fantastic. 243G means panchayat should implement their schemes, their own socio-economic programs, everything. Article 243ZD means there should be a district planning committee to integrate the plans of rural areas and urban areas. Great. State legislatures are to consider devolving 29 subjects listed in the 11th schedule for panchayats planning and implementation, focusing on economic development and social justice. Taxation powers and funding provisions for panchayats are determined by the states, which also lead in capacity building and ensuring accountability and transparency frameworks. Now, what does this mean? 29 subjects are there, which has to be, that is 29 subjects are there, which has to be devolved to the panchayats. That is, on those subjects, panchayats can make law, provided state gives it to the panchayat. If state doesn't give, panchayats cannot do anything there. Then, even when you talk about taxation powers and funding provisions, it's again determined by the states. That means when it comes to legislative powers, when it comes to financial powers, PRIs are dependent on states. So whatever you write beautifully in the Constitution, when you look at it practically, what is the whole point? If I am a PRI, to make a law, I should ask the state, please give me that subject. State will be like, no. Fine, you are not giving me that subject. At least to implement my own policies, please give me some money. Give me the powers to tax. No. And this is the reality not only for Panchayati Raj institution, it is true even for municipalities. So when you cannot make laws, when you don't have financial freedom, how are you going to expect that our panchayats will be beautiful or our municipalities will be doing a nice job? Never. Areas not covered under Part 9. While Part 9 of the Constitution applies broadly across India, Article 243M exempts certain areas. These includes Nagaland, Meghalaya and Mizoram states, tribal areas in Assam, Meghalaya, Tripura and Mizoram, hill areas with district councils in Manipur and district level panchayats in Darjeeling, West Bengal. These regions have their own grassroots local governance structures such as village councils. So here Part 9 Panchayati Raj Act, or basically the 73rd Constitutional Amendment Act, is not applicable. It is not applicable in these places. Why? Because they are tribal regions. They have their own way of culture to deal with things. There you have what instead? Village councils. Okay. Provision in the Constitution for PRIs. Part 9 of the Constitution incorporates the following mandatory provisions. 3 tiers of panchayat except in states with population below 20 lakhs. Direct election to seats at all 3 tiers of panchayat and indirect election to officers as per Article 243C. Indirect election for chairpersons of block and district panchayats, Article 243C, Clause 2. Reservation in seats for SC and ST in proportion to their respective population, Article 243D, Clause 1. Reservation of not less than 1/3 seats and offices of chairpersons for women, including within SC and ST reservations, under Article 243D, Clause 3. Rotation of reserved seats and offices of chairpersons, Article 243D, Clause 4. Election to panchayat every 5 years, Article 243, Clause E. To constitute the State Finance Commission, Article 243J, every 5 years. To review the position of panchayat and make recommendations to the governor regarding distribution between the state and panchayat of taxes, duties and tolls, etc. Setting up of State Election Commission, SEC, and vesting the superintendence, directions and control of preparation of the electoral rolls for and the conduct of all election to the panchayats in SEC, Article 243K. Why have I marked out specifically 4 paragraphs like this? Direct election to seats of all 3 tiers. Gram level, block level, district level. Direct election should be conducted. Correct? And to conduct that election, you need what? You need State Election Commission to be set up by whom? The state government. To decide on matters of finance, you need what? State Finance Commission. And all elections should be conducted every 5 years. Let me be very honest here. These are the 4 provisions blatantly violated by almost all the state governments in our country. Neither do they set up the State Finance Commission, number 1. Neither do they set up the State Election Commission, number 2. Why? If I set up State Finance Commission and I give money based on the State Finance Commission's recommendation, I start giving financial powers to panchayat. Panchayats will start becoming more independent. People won't be interested in state government and state government politics anymore. Because my water, I get it from the panchayat. My road, I get it from the panchayat. My electricity, I am getting it from panchayat. My internet, panchayat is providing me. Why will I be interested in state politics now? I may have an interest in national politics, definitely yes. State politics, whatever I need, my panchayat is providing. Then why should I depend on the state for what? Getting the point here. Number 2, my elected representatives at panchayat are doing a fantastic job. Why should I depend on the MLA then? This is the reason state election commissions are never constituted. State finance commissions are never constituted. And election to panchayats are never held on time. Some elections have been delayed now for more than 10 years. 10 years, no election at Panchayat. Because state government does not want to lose its grip over rural local bodies and urban local bodies. They don't want to let it go. This is the reason, one of the reason why government is trying to come out with what? One nation, one election. Why? Once you have one nation, one election, automatically after center and state elections are over, within 40 days after that, local elections to both panchayats, that is rural local bodies and urban local bodies, will be held. So there is no way any state can now bypass this. State can tell that no, we cannot conduct elections now. They cannot say it. And Election Commission of India will have all the electoral rolls for the central election, state election and local election. Getting the point here. Moving on. Compulsory conduct of elections. Timely conduct of panchayat elections is crucial for the effective democratic functioning of Panchayati Raj institutions. According to Article 243E, Clause E of the Constitution of India, every panchayat remains in office for 5 years from its first meeting unless dissolved earlier. Elections must be completed within this period or within 6 months of dissolution. State election commissions established under Article 243K of the Constitution in all states and union territories under Part 9 oversee the preparation of electoral rolls and conduct elections for panchayat. So 5 years, you should have a state election commission. They should overlook all the election activities. Correct. They play a crucial role in ensuring timely and orderly panchayat elections. This is what is written in paper. Fine. Reservation for women in Panchayati Raj institutions. Article 243D of the Constitution mandates at least 1/3 reservation for women in Panchayati Raj institutions, including seats and chairperson positions. Fine. Currently 21 states, Andhra Pradesh, Assam, Bihar, Chhattisgarh, Gujarat, Haryana, Himachal Pradesh, Jharkhand, Karnataka, Kerala, Madhya Pradesh, Maharashtra, Odisha, Punjab, Rajasthan, Sikkim, Tamil Nadu, Telangana, Tripura, Uttarakhand and West Bengal, and 2 union territories, Lakshadweep and Dadra and Nagar Haveli and Daman and Diu, enforce 50% reservation for women in other state Panchayati Raj Acts. In other states and union territories, Article 243's constitutional provision applies. Governance in 5th schedule area. So this is what it is. That is, elections to be conducted on time. State election commission has to be constituted. Every 5 years, election will take place. Women is having 1/3 of reservation. Great. 5th schedule area. So this is how it is for most of the country. Then what about in those areas where you have village councils or tribal councils? Governance in 5th scheduled areas. The 5th schedule of the Constitution governs the administration of scheduled areas and scheduled tribes in areas outside Assam, Meghalaya, Tripura and Mizoram. Article 244 provides special administrative provisions for scheduled areas in states other than these 4. Article 243M Clause 1 exempts scheduled areas and tribal areas mentioned in Article 244 1 and 2 from the application of Part 9 of the Constitution. That means in these areas 73rd Constitutional Amendment Act will not be applicable. Article 243M Clause 4 Clause B authorizes Parliament to legislate and extend Part 9 to scheduled areas and tribal areas specified in Clause 1 with exceptions and modifications without constituting a constitutional amendment under Article 368. Based on the Buria Committee's 95 report, Parliament enacted the provisions of the Panchayats extension to the Scheduled Areas Act 96 PESA, applying it to 5th scheduled areas and tribal areas as per Article 243M4B. The PESA applies Part 9 of the Constitution with modifications and exemptions to 5th Schedule areas under Article 244(1). So, two things are there. For some areas, Part 9 is not applicable. Some scheduled areas, it is not at all applicable. At the same time, for some scheduled areas, PESA, Panchayat Raj, is applicable also. So, where it is not applicable, under Article 243M, not applicable. Panchayat Raj Act is not applicable to certain scheduled areas under Article 243M, Clause 4, Clause B. Whereas, under PESA Act, some scheduled areas, it is applicable as per Article 244, Clause 1. Clear? So, 3 divisions totally. One is normal 73rd Constitutional Amendment Act, Panchayat. Almost, let us say, 90% of the country is filled with it. Or 90 is a little too much, maybe 70% let us keep. 70% it is applicable everywhere. Panchayat level, block level, Zilla level. Number 2, scheduled areas under 5th schedule, it is not applicable. PRI, Panchayat Raj Act, is not applicable. 3, Panchayat Raj is applicable to scheduled areas under the PESA Act. Clear? Currently, these areas exist in 10 states. Andhra Pradesh, Chhattisgarh, Gujarat, Himachal Pradesh, Jharkhand, Madhya Pradesh, Maharashtra, Odisha, Rajasthan and Telangana. That means scheduled areas within these states, they come under what? They come under the PESA Act. Additionally, the 6th schedule of the Constitution establishes autonomous districts to safeguard tribal autonomy and preserve cultural and economic interests of hill tribes. All right. Salient features of the PESA Act. Every village shall have its own Gram Sabha. A village may consist of one or more habitations or hamlets comprising a community and managing its affairs in accordance with traditions and customs. In Part 10, all electors of village panchayat constitute a Gram Sabha. Gram Sabha is competent to safeguard and preserve the traditions and customs of the people and cultural identity, community resources, customary mode of dispute resolution. That means under the PESA Act. Which are the states again? Andhra, Chhattisgarh, Gujarat, Himachal Pradesh, Jharkhand, Madhya Pradesh, Maharashtra, Odisha, Rajasthan, Telangana. What tribal people are there? Scheduled tribes are there. PESA Act. They can form a Gram Sabha. Okay. So who all are the members of a Gram Sabha? All the electors of village panchayat constitute a Gram Sabha. People who are more than 18 years old. And these people will manage tradition, custom, community resources. This is the main highlight here. If you look at that names of those states which comes under PESA, one thing that you should understand is PESA states are pretty famous for what? Mining. They're pretty famous for that. But if mining has to be done from there, it is a community resource owned by the entire village. You will have to take the approval from whom? Gram Sabha. Any state that wants to do development, any state that wants to increase their economic growth, will they like if a Gram Sabha is there? No. Why? No Gram Sabha in its rightful mind will entertain what? Mining. Most of the Gram Sabhas, we can easily say, are against mining. Getting the point here. One more reason why no state is interested in what? Implementing PESA. Gram Sabha's mandatory executive functions to approve plans, programs, and projects for social and economic development. Like I told you, you need the approval. It's a law. If I am company, I want to do mining there. That area comes under PESA. That means I should take the approval from Gram Sabha. Identify persons as beneficiaries under the poverty alleviation and other programs. Issue a certificate of utilization of funds by the panchayat for the plans, programs, and projects. Powers exclusive to Gram Sabha or panchayat at appropriate level. Right to mandatory consultation in land acquisition, resettlement, and rehabilitation of displaced persons. As far as land matters are concerned, I have to consult Gram Sabha. Panchayat at an appropriate level is entrusted with planning and management of minor water bodies. Panchayats gets involved there. Mandatory recommendation by Gram Sabha or Panchayat at appropriate level for prospective licenses or lease concessions for mines and minerals. This is mandatory, people. Clear. Powers endowed to Gram Sabha and Panchayat at appropriate level to regulate sale or consumption of intoxicants, ownership of minor forest produce. This is the other area where now conflict has started between Forest Department versus Gram Sabha. Prevent land alienation and restore alienated land. Manage village markets. Control over money lending to STs. Control over institutions and functionaries in social sector. Local plans including tribal sub-plans and resources. The PESA Act integrates the directive principles of state policy outlined in Article 40 of the Constitution for establishing virtual village republics in 5th schedule areas. Its effective implementation aims to benefit tribal populations several ways, institutionalizing self-governance and enhancing people's participation in decision-making through Gram Sabhas at village level, empowering tribes to control and utilize public resources, reducing alienation in tribal areas, mitigating alienation and resentment, potentially curbing left-wing extremism in affected districts. This is the key highlight here. Enhancing livelihoods by enabling control over natural resources like water bodies, forest produce, and minerals. Strengthening local economies and minimizing exploitation through regulation of money lending, liquor consumption, village markets. Preventing illegal land alienation and restoring unlawfully taken tribal land, improving socioeconomic status and reducing conflicts, enhancing the implementation of developmental schemes through increased local participation in planning and beneficiary identification, ensuring more accountable and responsive local administration with authority over social sector functionaries and utilization certificates, preserving cultural heritage and identity by safeguarding traditions and customs of tribal communities. Same thing. Don't get tensed, please. These things are again just meant for your information. Once again, I will sum it up for you. That is 74th Constitutional Amendment Act. Almost everywhere. Then you have exception under this. 5th schedule areas. They have their own village councils. Then you have what finally? Panchayat extension, Panchayati Raj extension to schedule areas, where main point of contention is what? forest produce, water bodies, and then mining versus government, private companies. So no government in its rightful sense will ever try to implement PESA. Why? Because PESA gives huge powers to Gram Sabhas. Clear, people? Okay. Promotion of cultural heritage through preservation of traditions, customs, and cultural identity of tribal population. Okay. Analyzing PRIs. This is where I think our current affairs will come in. Yes. Yes. That we will take it up tomorrow. Okay. This is what we really need. The other portions, whatever we have discussed so far, go through it again. This is the summary of the entire thing. Okay. Just remember a few articles. 243M, 1 second. Let's not make it wrong. Yeah, 243M and 244. Okay. Okay, people. So that will be about it. Let's call it a day.